In the past, it's so simple. You can basically ignore the Employment Act. But now it's the opposite.
My name is Liaw 𝐿𝐵𝐵, employment lawyer and the principal of Liaw Chambers.
One of the most important changes to the Employment Act brought about by the Amendment Act 2022 is the expansion of the scope of the Employment Act. The Employment Act now covers way more people, way more employees than it used to. This is due to the amendment to the first schedule to the Employment Act, which defines who is an employee. It is only when you are an employee that is as defined by the Act that you fall within the protection of the Employment Act and that the provisions in the Employment Act applies to you. So by changing what is the definition of employees in the first schedule, it changes the scope and the coverage of the Employment Act. Now, under the revised first schedule, everyone that is in a contract of service, regardless of the wages that they receive, is an employee and the definition of the Employment Act. One thing that is always raised in the past is that the Employment Act only applies to people that is 2,000 ringgit and below salary. And anybody that receives salary above 2,000 ringgit is not an employee as defined in the Employment Act, and therefore the provisions and the protections of the Employment Act do not apply to them. But that is no longer the case after the amendment. Now all employees are covered as long as they are in a contract of service and not contract for service. Then regardless of the amount of wages that you earn, you are under the protection of the Employment Act. It is only that certain provisions in the Employment Act that do not apply to employees with salary exceeding 4,000 ringgit. So the whole Act applies to everyone who is an employee, but some provisions are exempted for employees who earns more than 4,000 ringgit. And even then, if you are under specific categories of employees, such as if you are in manual labor or you are a domestic servant, then even though you may earn more than 4,000 ringgit, these special exempted provisions still apply to you. So what are the exempted provisions? Rest day pay, pay for work done beyond normal hours of work, which is OT, regulations relating to entitlement of allowance during shift work, pay for work done during public holidays, holiday pay for work done when public holidays fall on a half working day, termination, layoff, and retirement benefits. These are what we call exempted provisions. These are the only provisions that do not apply to an employee if the employee's salary exceeds 4,000 ringgit. But if you fall beneath the category or categorization of a manual labor, of a domestic servant, then even if you earn more than 4,000 ringgit, you are still entitled to this pay. So with the expansion of the scope of the Employment Act, what are the protections, what are the benefits that employees are entitled now that are provided by the Employment Act? They are such as termination notice, sick leave, hospital leave, working hours, holidays, annual leave, as well as the right to sue. The simple way to describe this is that in the past, if you look at an employee and you know that he's earning more than 2,000 ringgit, you can basically ignore the Employment Act and you just look at the contract that you have with this employee. If the employment contract says that he has this entitlement, you must pay. If the contract doesn't say that he is entitled to this thing, you don't need to pay. It's so simple. You can basically ignore the Employment Act. But now it's the opposite. Whatever employees, you must always refer to the Employment Act and see what are they entitled to, even if your contract doesn't provide for it. But if the Employment Act provides for it, you have to provide the same to this employee because he is now an employee under the Employment Act.